This retired Scottish academic has never met Nicky Kelly. In fact, until we approached him about 1 month ago, Andrew Morton had never heard of Ireland's best-known supposed train robber. But tonight, he enters the Nicky Kelly case centre stage. For Mr. Morton has dramatic new evidence that threatens to blow Kelly's case wide open. After careful study, he has concluded that the basis for Kelly's conviction 15 years ago was a sham.
I'm perfectly confident that this cannot be accepted as a statement which is the utterance of Mr. Kelly.
I believe Nicky Kelly was wrongly convicted. I believe Nicky Kelly's confession should not have been admitted in his trial.
I believe he is telling the truth. I've met him several times and I've been impressed by him. But apart from that...
But if he was telling the truth, then others were not.
I think so. That seems to be absolutely the only conclusion. But I think we should have to face up to that, yes.
That's quite a serious matter, you'll agree.
Oh, it is serious, but at the same time, I think fiat justitia ruat caelum is an old. Let justice be done even if the heavens fall.
Come on, give us a name! Now! Come on, give us a name!
For 15 years, Nicky Kelly has stuck to his hair-raising story of being beaten by Gardai and forced to confess to a crime he says he didn't commit.
All right.
The judges, right up to the Supreme Court, have thrown out Kelly's case time after time. They've simply refused to interfere in the trial court's decision.
I've an innocent person who is still guilty in the eyes of the law.
Kelly was convicted with a number of others of a large-scale train robbery in 1976 at Sallins, County Kildare. There was no other evidence against him, only a confession which he had signed. Others convicted with him have since had their convictions quashed. But not Kelly. He is today still legally a guilty man.
I try not to be totally obsessed by it, but the reality is there, and until I am exonerated, I cannot fulfill a normal life. I never try to ram it down people's throats that I'm innocent, full stop. I just said, look, just look at the facts.
Just 1 year before Kelly's trial in 1977, the Minister for Justice, Patrick Cooney, received worrying news. At a meeting with representatives of the Association of Garda Sergeants and Inspectors, he was informed that a small number of Gardai were systematically abusing and assaulting suspects under interrogation. No names were supplied. The minister felt he had no proof. A year later, Kelly's case was to start badly for the judges. One of the 3 special criminal court judges was seen from the court to be regularly falling asleep on the bench. Despite the evidence, the judges ruled that he was competent to fulfill his duties. Shortly afterwards, the unfortunate judge, John O'Connor, died. He had clearly been ill. The trial was aborted, a new trial called after 70 days. Next, the Garda statements in the Book of Evidence raised a few eyebrows. Some of them showed a remarkable similarity of language. Here's one passage taken from the statements of 4 separate Gardai, but here appearing to speak as with one voice.
Plunkett said, "You fixed that nicely."
And Garda replied,
"Is it not true that you were freed and you asked to go back to collect property?"
And Plunkett said, "That's right."
Gardai then said, "I don't know what you're talking about, but I can assure you one thing, we fixed nothing." "What are you talking about anyway?" Plunkett replied, "A man in there has identified me as being one of the men in his home on the night of the robbery." Gardai asked, "Is that so?" Garda B said to Plunkett, "It was you who delayed leaving the station." Plunkett said, "That's right."
Severe bruising on the right shoulder.
Kelly's case was dominated by the fact that he had been heavily beaten while he was in Garda custody. This was the central issue in his trial. Because if these injuries had been inflicted by the Gardai, then his confession could not be voluntary and he would have to be acquitted. So the question was, who caused these injuries? Kelly's story to the special court was that his confession was totally false. He'd signed it only to put a stop to over 24 hours of beating. He told judges Clark, Hamilton and O'Flynn that he had nothing to do with the Salins train robbery.
I was beaten on all stages during the interviews, except for short lulls. I was beaten right through Monday night, early into Tuesday morning. I was transferred to another police station, and the next morning it started again. And continuously throughout that Monday, Tuesday night, Wednesday morning, the beatings continued. For example, the ear injury that I suffered, I think, and continuing to suffer from to an extent, was inflicted by cupping, what is called cupping, that's beating the ears from behind with both hands over a period. It frightened me, scared me, and I found it very degrading. You know, I was very scared, you know.
In his court evidence, Kelly accused by name a small number of his principal interrogators, all of them detectives. No uniformed guards were implicated in his charges, and he said that many of the detectives who dealt with him never laid a finger on him.
All the time I was being asked to admit, own up, admit. Also then I had what was water, which I was told was holy water, thrown on top of me. This happened a number of times, and the reason they said they were doing this was they had informed me earlier that my mother, at some stage earlier on, that my mother had a heart attack, and if I owned up and signed a statement, they would take me to see her. And they repeated this a number of occasions, and then they produced this water and threw it on top of me. Said I didn't care about my mother. Eventually, at some 4 or 5 o'clock on Wednesday morning, I signed the statement, something I did not do. I signed them to stop the beatings, and that was what, at that particular stage, what was in my head. And that's what I was being told all along, that the beatings would continue until I signed the statement.
3 detectives that Kelly identified in the court as having beaten him while in custody were Detective Garda Thomas I. Dunn, Detective Garda Michael Finn, and Detective Sergeant Patrick Cleary. But the court received very different evidence from the Detective Gardaí in this case. In this evidence, no one had ill-treated Kelly. He was questioned, according to the Garda evidence, properly and without violence. He never asked for a solicitor, as he claimed. And eventually, at 5 o'clock in the morning, he decided to make and to sign a detailed statement confessing to the crime. It was a point of view that the special court heard from all the detectives who questioned Nicky Kelly.
I have to put it to you that all through, your attitude to Mr. Kelly was one of hectoring and threatening him.
No, my lords.
First of all, that on several occasions you slapped him.
I never touched Mr. Kelly, my lords.
That on several occasions, not 1 or 2, but many more than 1 or 2 occasions, you punched him.
No, my lords, I did not.
Particularly on the arms.
No, my lords.
And threw him around the room generally.
No, my lords.
You disagree, first of all, that you beat him with a blackjack.
I do, my lords.
And he wasn't beaten by you in any way other than with a blackjack.
No.
My instructions are that having refused to sign after your great industry, you then started to beat him with a blackjack for the 3rd and last time.
That never happened, my lords.
Having beaten him with a blackjack, shoved him around, he said, "Very well, I will sign."
Nothing like that ever happened, my lords.
What was your attitude towards the accused at these various meetings and interviews?
Courteous at all times.
Did you make any threats to him, attempt to intimidate him in any way?
No, my lords.
Did anything of that sort happen in your presence or hearing?
No, my lords.
A person changes his mind. He admits his guilt. It's as simple as that.
From start to finish, you saw nothing, heard nothing that would cause you to believe he was beaten.
I still believe that at no time was he assaulted, threatened, or abused.
Detective after detective gave evidence along similar lines. None of them had assaulted Kelly. None of them had heard or seen evidence of any other person ill-treating him. But the Garda evidence shed little light on precisely how Kelly had sustained his injuries in the first place.
There was medical evidence in the case which suggested that he'd suffered injuries in custody. This evidence was given by people of impeccable character and integrity.
What were these injuries consistent with?
The injuries were consistent with the person having come into contact with some object.
Such as?
It could be anything.
A fist?
It could be.
Or perhaps a kick?
It could be.
And would the injuries you found, the bruising behind the right ear, be consistent with being struck by a hand, or a half-clenched fist and being beaten around the ears like that?
No, I couldn't rule it out.
These various injuries present, matters that you noticed, distressful state, what were all these matters consistent with, in your opinion, as a doctor?
They were consistent with the type of beating which he described to me.
The bruising which you found? Take the upper arms. Can you say that was consistent, or was it not? With a series of punches by different people at different times?
Yes, I think repeated punching.
Doctor, what exactly do you mean by extensive bruising of both arms?
Covering 2/3 of the arms.
On each arm?
On each arm.
You have stated the bruising was consistent with a number of causes. What causes are they consistent with, in your opinion?
They could have been hit. They could have fallen.
Could they be consistent with being hit with a cosh or a blackjack?
Possibly.
But there was other evidence also from inside the Bridewell that night. A number of prisoners who were being questioned there for various offences gave evidence of strange goings-on in the early hours of the morning.
At about 2 o'clock, we were woke up by someone screaming.
What kind of screaming?
Like someone was getting a hiding.
The incident you were asked about, the 2 hours screaming, was it such that anybody in the place listening to it could hear it?
Anyone could hear it, yeah. Like, I could hear someone saying, you did it, and someone getting the thumps, you know? And the bloke was saying, I didn't do it, things like that.
I heard somebody shouting, I didn't do it, and somebody replying, we know who drove the car, we want to know who drove the van. Car or van was mentioned.
How long did you hear the noise, or shouting, as you describe?
It went for several hours at least.
You started banging on the door.
Yes.
Did the jailer come along to you?
Yes.
How did he react?
I just said, was there any chance of getting the screaming stopped? And I told him I'd never heard such screaming before in my life.
Eventually, the court delivered its ruling.
The court has carefully assessed all the evidence, has had regard to the demeanour of the witnesses.
The question was, had the state proved beyond all reasonable doubt that Kelly's confession was voluntary? The independent medical evidence alone suggested such a doubt existed, but the judges, having considered all the evidence, took a different view.
The court is satisfied beyond all reasonable doubt that the statements alleged to have been made by the accused were made by the accused voluntarily and were not made as a result of any assaults, ill treatment or improper methods employed by the Garda Síochána.
There was no direct evidence before the court that anyone other than the Gardai had beaten Kelly. However, as the court had ruled that the Gardai were truthful, there had to be some other explanation.
The court accepts that inherent in its findings with regard to the accused, it has drawn the inference that the injuries suffered at the time of medical examination were self-inflicted or inflicted by collaboration with persons other than members of the Garda Síochána.
We should have at the earliest moment a transcript of your lordship's judgment. It contains reasoning and astounding findings of fact.
I beg your pardon, Mr. Soran. What do you mean by that?
Surprise and...
Are you surprised?
Yes.
Then kindly do not make insinuations beyond that then.
But the decision frankly shocked many lawyers. Amnesty International was to accuse the special court of failing to follow rules of evidence regarding reasonable doubt.
I believe the court was wrong. I believe it was open to the court to find that the confession had been involuntary.
However, an unusual series of actions by the authorities had left open the possibility that Kelly's injuries were self-inflicted or inflicted by a co-accused. In an unprecedented move after being charged, Kelly was returned to the Bridewell and police custody overnight and not to Mountjoy prison as normal. Mountjoy prison is extremely close to the district court, and it is unknown for a prisoner in the Dublin area not to be remanded there after being charged. This unique remand was to prove a critical development in this case.
When he was remanded by the district court, he was remanded back to the Bridewell station. In the ordinary course of events, an accused would expect to be remanded to Mountjoy prison. It has never been satisfactorily answered as to why he was remanded back to the police station.
If we had been remanded, as we should have been, to Mountjoy, we would have, on entry to Mountjoy, we would have been examined by a doctor.
There was now a second unusual event. In breach of the Bridewell's own rules, Kelly was placed two to a cell with his co-accused.
Come on, up. Get up.
He was put into a cell with a co-accused. Now, that's inconsistent. That was in violation of the applicable rules. Why he was put in the cell with a co-accused is a question which has never been satisfactorily answered.
I think there was something very fishy about the whole thing, and that I think there was a basic injustice involved in this whole area.
The court found itself, the judges found themselves in a situation where it must have been very difficult for him to come to terms with that situation.
Were his injuries, in your view, consistent with him either beating up himself, as the court decided, or being beaten up by his co-accused in the cell, as the court also decided?
No, they weren't.
Well, that's what the court decided.
I know that. But the court was wrong.
You had a very clear opinion about this matter at the time.
We had a very clear opinion about this matter. Dr. McGee and myself discussed this matter in very great detail, and we concluded that this evidence could not have been self-inflicted or inflicted by some of his colleagues.
So why did the court decide otherwise?
That's a 6-mark question.
In the course of the 1980s, Nicky Kelly was examined on a number of occasions by Professor Robert Daly. Daly is one of 2 Irish government nominees on the European Committee Against Torture. He advised the Irish government in its torture case against the British at Strasbourg in 1973. His authority as a psychiatrist is unquestioned in his field. His view of Nicky Kelly is clear.
There are such people as malingerers who are pretending to have symptoms which they don't have. It's possible. But in this case, everything I saw about the demeanour of Nicky Kelly and the history and my examination of him was consistent with the events that he described.
Was it consistent with him having beaten himself up or being beaten up by a colleague in a cell?
No, I don't think that was consistent in the sense that the detail and the overall history would be difficult to simulate in that way.
Is that a clear, firm, professional opinion that you would have on this case?
Yes, that's my professional opinion, based on cases in very large numbers elsewhere.
The extent of the injuries were quite extreme, and some of it was long-term. And why would anybody be crazy enough to inflict long-term damages on each other?
I believe Nicky Kelly is truthful. I've met the man several times and I've been impressed by his character, his honesty. And of course we mustn't forget also, of course, that the IRA have publicly admitted that they did a Salins robbery.
Kelly absconded before his conviction, but later returned to face jail. From jail, he appealed the verdict. But he ran into a series of legal stonewalls. First stop was the Court of Criminal Appeal. Here the judges felt unable to second-guess the special court's decisions.
This court is satisfied that it is open to the court of trial to reach the conclusions that it did, and to reach them beyond a reasonable doubt. And on a review of the whole of the evidence, this court cannot say that those conclusions were perverse or insupportable.
Next, the case was appealed to the Supreme Court, but the Supreme Court also refused to review findings of primary fact made in the court of trial in the Nicky Kelly case. Again, the judges said no.
Involved in this submission is the assertion that the Court of Criminal Appeal could and should have concluded from a reading of the transcript that the various Garda witnesses involved in the allegations of ill treatment committed perjury. The judgment of the Court of Criminal Appeal was correct and should be upheld. In my view, this appeal should be dismissed.
What was happening to Kelly was that the higher courts were simply refusing to reopen the issue of assault. The special court had seen the witnesses and its decision was final. Nicky Kelly now went on hunger strike in Portlaoise. As he came off this fast, the Irish government reminded him that he was free to pursue his case in the civil courts. But when Nicky Kelly did this, the same Irish government blocked him. The long shadow of Lord Denning and the Birmingham Six was about to fall across his case.
Lord Denning, Master of the Rolls, took the view that estoppel could be pleaded to prevent that party relitigating the same issue before another court. I hold that the plaintiff is precluded by reason of the finding already made by the Special Criminal Court from reopening the same issue in the present civil proceedings for damages.
So, Lord Denning's infamous judgment, which frustrated the Birmingham Six's search for justice, has been the authority used by the Irish government and accepted by the Irish courts to block Nicky Kelly. Denning had used honest, if unwise, language.
If the 6 men win, it will mean that the police were guilty of perjury, that they were guilty of violence and threats, that the confessions were involuntary and were improperly admitted in evidence, and that the convictions were erroneous. This is such an appalling vista that every sensible man in the land would say it cannot be right that these actions should go any further. They should be struck out.
I think people fear the spectre of an appalling vista in this case. In other words, if there's been a miscarriage of justice, if when the rock is overturned, something awful is there to be seen, well then it has implications for the role of the police in the prosecution of Nicky Kelly.
I think this case does leave a stain upon our own integrity as a people, and therefore I would love to see something being done, some inquiry to be set, or even to go even an appeal to the Court of Human Rights to satisfy those of us, and many, I think the vast majority of the Irish people would feel happy if Kelly were vindicated. I think it's, in its own way, it's on a par with the Birmingham Six case. I really do. It's serious at that.
Don't you think it's ironic that the Irish authorities would come over here and say one way to prove a system correct is for that system to put itself right, and therefore the police system looks as if it's trying to put itself right in our case, when the Irish government and the Irish authorities refuse even to do anything in the Nicky Kelly case? Why don't they get their house in order?
It may be that this man will be of some assistance. Andrew Morton is a Scottish academic an honorary fellow of Glasgow University and a pioneer of a new research area into linguistic patterns. Mr. Morton was commissioned by RTE to apply his methods and computer skills to the Nicky Kelly case. His test, he says, has the same validity as the taking of a fingerprint.
A fingerprint is a pattern of skin in the end of your fingers. It shares common characteristics, but has individual ones, and from this pattern you can be identified. Exactly the same way you have habits, the way you choose and arrange your words, and we're making a little picture which really is rather like a fingerprint of your mind.
It's a new and developing area of research which has now been endorsed by the Court of Appeal here, linguistic analysis, which can show in a convincing way to a judge or a jury that words allegedly spoken by a suspect could not have come from his own mouth. They do not conform to his manner of speaking, and that can now be established scientifically.
Mr. Morton's evidence and methods were accepted in the British Court of Appeal last July. His testimony led directly to the quashing of a 12-year sentence for armed robbery.
The judgment made by the three justices was that had this been presented to the jury, they might well have come to this conclusion, so they quashed.
They found this new area of scientific research to be valid and convincing, and acted accordingly.
Yes, what we have is a technique that is now accepted in court.
It is authoritative, and interestingly, the scientists who are producing it are not slaves to the defence.
As we've seen, in the Nicky Kelly case, there was no evidence against Kelly except his own signed statement of confession. Kelly has always said he didn't compose this statement or dictate it. The guards swore that he did.
I was asked to look at Mr. Kelly's alleged confession. Now, the first thing one would do is say, is this the work of a single person? Should it be? The next question would be, is it Mr. Kelly? Well, the Kelly's confession is not the work of one person. Again, it's a mixture. There are certainly two people involved. Now, you can't say much past that, because after that you might have two people, X and Y, and you might have a mixture of X and Y. But it's certainly not a single person, and it cannot be accepted as the utterance of Mr. Kelly.
You have no doubts about that?
Oh, none at all.
What Mr. Morton has basically done is to take an undisputed sample of Kelly's authentic language and reduce it to graph form. Against this, he placed the linguistic pattern of the supposed confession. The gap between the lines is the sign of different authorship, the giveaway. This graphic illustration has left Andrew Morton with only one conclusion.
This is supposed to be exactly what he said, written down exactly in the order he said it, nothing added, nothing omitted, and this is certainly not true. You cannot accept it as a genuine specimen of Mr. Kelly.
I've read the material that's come from Mr. Morton, and I take the view that it's both very relevant and very important. And I think that if it had been available to the Special Criminal Court when this case was originally tried, that the outcome might have been totally different, that Nicky Kelly might well have been acquitted.
So is it of sufficient weight, in your opinion, that the Nicky Kelly case should now be reopened?
Yes, I think it is. Unfortunately, Nicky Kelly has exhausted his right of appeal to the Court of Criminal Appeal and to the Supreme Court, so it can't go that route. It can't go back to the courts.
There is no mechanism for reopening it?
There is no mechanism for reopening it, except perhaps by way of pardon.
And is this evidence from Mr. Morton, in your opinion, of sufficient weight that the state should consider a pardon?
Yes, I think the government should be seriously considering pardoning Nicky Kelly.
Two comprehensive and disturbing books have been written about this case. Each of them caused ripples when first published, but like the court cases, failed to shake the authorities into action. The Bridewell in Dublin, where Nicky Kelly was held. It's a building dedicated to the triumph of justice. Those who built it decades ago even inscribed this principle across its front for all to see, a commitment to justice, whatever the cost.
Via justitia rua caelum. Let justice be done even though the heavens fall.
Some people are afraid that the heavens might fall, perhaps if justice were
I don't
done.
think so. I think that would be, the country itself would be much happier and would put hold its head high. I mean, everybody makes mistakes. We all make mistakes.
It's clear that despite all the litigation on this case, the courts have failed to remove a cloud of public unease that has always surrounded this matter. And while Kelly can still go to the Supreme Court on the issue of a civil action, perhaps responsibility should now shift to the state. Only a small number of detectives have been implicated by Kelly in assault. Most of those he met while in custody did not assault him. But if Kelly was beaten, then it's the state's job to identify the culprits. The Irish state prosecuted Nicky Kelly. Today, only the state can exonerate him.
It's not going to go away, and they are going to have to come to terms with it. The same as eventually, or inevitably, the British government had to come to terms with the Guildford, Birmingham cases, the Maguire case. The Irish government will have to come to terms with their own miscarriage of justice.
People would have a greater confidence in our institutions if we were all prepared to stand up and say, listen, we did make a mistake on that occasion, and we'll try to do better in the future.